Okay, I'm Robert C. Dupree again, and as I was stating here concerning, the mandate order and how that the judge and the courts and them had mandated my order because I've continuously requested that this judge, Gary A. Fenner, would get off of the case as according to law he never should have been on, and if he was on it, he should, according to law, been recused off of it. But nevertheless, the opposing counsel, Kevin Mason, who was the attorney of record of the White Ghost law firm, he just insisted, and the defendant, Lamar's advertiser and him, they had vigorously opposed my opposition of getting this judge of recusing himself off the case. And unfortunately, the courts refused to do anything about it, despite my constantly appealing and my constantly complaining, about him recusing and getting himself off the case. He refused to do it. Matter of fact, I'm going to read what the opposing counsel had stated in his strong opposition here and regarding my complaint and how he strongly opposed here against this here. And I'm going to read this here. And it was filed, what's that, 9/22 of 2015. And this is what he stated here. The opposing counsel here, this is what I'm reading here about Kevin Mason here. The opposing counsel, Kevin Mason, and the defendant strongly aided, in the conspiracy against civil and constitutional rights to plaintiff or of plaintiff pro se, filing motions and opposition to have Judge Gary A. Fenner to be recused. They strongly opposed having him being recused in spite my motions and my rights to have him recused, that laws say I have the right to do so. Let me finish this here. And the defendant opposition to the motions for recusal that was filed 9/22/2015. And attorney Kevin Mason stated on page 1 of 5. Plaintiff Robert Dupree has have asked the court in 3 separate filings for an order of recusal in this lawsuit, which is true, I did, and even more so. Now, speaking about attorney Kevin Mason, this is what he stated now, and how he fabricated and lied and falsely stated statements regarding the laws pertaining to this here. Let me say here, and attorney Kevin Mason fraudulently and intentionally lied, giving false statement, misleading the law by, means of conspiracy, also stating that Dupree's filing, in the applicable laws, there is no basis for recusal. In other words, Kevin Mason, the attorney who is the opposing counsel representing defendant Lamar's and them there, they saying there's no laws. He stated there's no laws, no applicable laws of any sort that justify the judge, that justify the judge, Gary A. Fenner, to be recused off of the case. This is what Kevin Mason here, the opposing counsel, has stated around up over here in the written documents, making false statements and lies and things pertaining to this here. And I'm going to look at this here again. I'm going to read that part again, where he's talking about stating Dupree's filing, in the applicable laws provide no basis for recusal. Stated there's no laws, despite obvious facts. But anyway, let me finish this here. And here it got down here in the U.S. District Court, how did it fraudulently transmitted a notice, of appeal, in this matter. And the case number here that originally was the case number down here before they transferred it up to they appealed it up to the Court of Appeal. The original case number here was 415-CV-00629-GAF to the U.S. Court of Appeal for the 8th Circuit, and docket it under, the capturing, and gave it a new case number. and the case number was 17-1817. Robert Dupree versus corporate Lamar's Advertising, to a case that was never here it is, a case that was dismissed January 27 of 2016 and never reopened. This judge, Gary A. Fenner, he closed this case, never reopened it, and then for some strange reason or another, all of a sudden I'm getting a notice from the district court and from the Court of Appeal that, hey, this case has been appealed. Never been reopened. And furthermore, what even makes it more ironic, I never appealed this case. If anything, or anyone should be appealing this case, it would be me. But no, they appealed it, and they gave it a new case number. Now, earlier I was telling them they were recusal judge. I even mentioned and stated that, hey, give it a new venue. No. They decided that, hey, since there's been so much heat and complaining on my behalf against Judge Gary A. Fenner down here in the federal court downtown here, you know, for the 400 East 9th Street downtown Kansas City area around up over here, well, they just figured that, hey, well, they're going to appeal it, even though they never reopened it. As a matter of fact, it was so severe, my continuously complaining and requiring, as by law, which is my right, because the law is on my side, to have this judge recused and removed off this case. This judge, Gary A. Fenner, got apparently so angry and upset about it, he ordered that any of my motions that will be filed requiring for him to be recused off of this case, they would consider it void. Matter of fact, this is what it was. They voided it. If you can see that on there, they voided it. Any motions requesting for me, requiring for Judge Gary A. Fenner to get off this case, they just totally voided it out. Now, concerning the laws and things, which Kevin, the opposing counsel, Kevin Mason, falsely alleged that there was no applicable laws requiring for Judge Gary A. Fenner to be recused off of this case. Well, I want to briefly take this few minutes here, or a few seconds here, and look at these laws here, and just briefly kind of look at some of here. Now, concerning federal laws pursuant, say, to Rule 28 U.S.C. 455A and under Rule 28 U.S.C., recusal is mandatory in any proceeding in which his impartiality might reasonably be questioned. Missouri federal laws disqualify judges here under the Rule 50-1, say 5, and now provides the procedures by which a party can proceed and or change, say, a judge in a civil matter. Here's laws right here that clearly states that, you know, not only is a judge required mandatory to be removed off of a case if his impartiality is in question, but there's laws that provides and give us as plaintiffs or whichever the rights to request the judge to be offered these cases around here when the laws requires for him to be so. And particularly say a change of judge shall be ordered in any civil action up on the timely filing or a written application, therefore, by any party. And I have perpetually been complaining and filing complaints about this judge being offered this case. And especially because of my complaints that I had to file to him, or against him rather, back in the previous lawsuits when he proceeded over with General Mills and the unions and him around up over here back in 2010. And the unfortunately the fraudulent and criminal act that he had committed by lying and withholding information and refusing to send documentation and things up to the higher up court, which is required by law for him to send up, which he didn't, and so forth. So this is another reason why the law is in my favor, that he should not have been on this case, especially when it still involves old entities. The only thing that's new basically is now defendants, and that was Lamar's advertising and this matter around up over here. So anyway, the law is provided that any judge, should be removed off the case where it's mandatory. And I want to look down here also at this other part here, and pursuant to that rule, whenever a party properly present and serve a change, say of judge, applications to request for a change of judge must be sustained unless it had already been existed. Well, anyway, that wasn't the issue here, that he had been removed once before. This is what I'm saying. And the opposing counsel, the defendants, and even the courts, definitely the courts, they all was fully aware, and I made the opposing counsel fully aware of why I did not want this judge on this case. But yet, it continued, and the court said, hey, we're going to have a mandate order because I refuse to pay this $505 filing fee, which I didn't file or appeal the case. They appealed the case, and the reason why they appealed it, and I stated, I believe, earlier and previously, and I will continue to state that it was to get me away from the court of jurisdiction, away from this judge, Gary Fenner down here, which I had many of complaints filed against him because of judicial misconduct. And the evidence is right there in black and white. It's all in court documents, and even all the way up is even mentioned. I even mentioned about this in the United States Supreme Court, about this judge here. Now, this was before I got on with the Lamars and things here for us, because the United States Supreme Court, and even I made statements concerning this judge here before that of such. But however, they mandated, and the judges, they just closed this case, and they saying now the case here is closed because I, plaintiff, pro se Robert C. Dupree, whichever, did not pay the filing fee to appeal, which he appealed, they're alleging. Well, I didn't pay the filing fee of this here. No. And I told the courts and them, that, hey, I didn't appeal this here, and no, and I wasn't going to pay that, because, like I said, that just added more in the conspiracy against myself for what they're doing for me to do that. And that wasn't going to happen. So nevertheless, so now they put a mandate on it and stated that, well, since I didn't pay this filing fee of $505, well, hey, we're going to close this case, and now the case has been striked, it's ordered. So if any motions that I file in opposition, which I still do, well, they just don't file it and they return it back. And speaking about return back, it was pretty ironic, and I brought to the court's attention on this here too, on one of my returns back in my opposition against the courts closing my case with a mandate order and so forth. What they put on here, I don't know if you was able to see that or not. You probably can't. But anyway, they got on my statement here, legal matter open in the presence of an inmate. Legal matter open in the presence of an inmate. I looked at that and I pondered, and I said, well, I know I don't know anyone in jail or it's incarcerated, and I certainly don't know anyone that I will be writing to or someone will be writing to me. And due to the nature of my issues that I'm having with my rights and things being upheld, and going through the judicial court system and stuff around here that I'm involved with, and I personally took that as a personal threat, meaning that, hey, they folks are saying in their own way, underhanded that is, that, hey, we'll wind up putting you in jail around here if you constantly making statements and things in opposition against what we are saying, that this case is being closed. We're going to wind up putting you somewhere, and I really, was really offended about this here a little bit, and I definitely addressed this matter, not only to them, but I also addressed it to the FBI. I also made that known to the NAACP, and I also made it known to our congressman, Emmanuel Cleaver. So I made sure, I made it known first to the courts, then, about my concern of such, and due to the nature of what I'm involved in dealing with, and standing up and fighting for my rights, and especially bringing this to social media and opposing and bringing out about what General Mills, what they had done and my experience with them. Well, you know, to me, I took this as a serious threat. Legal matter open in the presence of an inmate. Come on. I ain't never, and of all my mails, and I've been dealing with the courts in and out for ages, years rather, not ages, but years, that, you know, I ain't never heard that's come talking about open in the presence of an inmate, or don't, unless, yeah, open here, what it says there, legal matter open in the presence of an inmate, you know. And like I said, and I stated again, that's due to the nature of what I am involved in dealing with. I just believe that this was another underhanded method of saying in their own way, you know what, we will wind up putting you somewhere you don't want to be, in this place called jail or incarcerated or whatever it is. And I certainly addressed that to the court's attention, to the court of appeal, to the court clerk, to all of them. So I'm not just blowing smoke in the air. It is, whether they filed it into the courts or not, and chances are they didn't, but they did receive it, so they know. And I express strongly the reason why, because of the injustice that I'm continuously experiencing perpetually over and over and over, and perpetually been going through the court system as laws requires, but yet continuously been deprived and denied. And someone, no doubt, had probably got pretty upset about that, and so they sent me a message through this stamp here on my returned motion that is in strong opposition against the mandate order of the court closing my case, and requesting that this will be reopened and so forth, and back and put into the court of original jurisdiction. Well, they saying they're not going to open it. It's been ordered closed because I didn't file or pay, rather, I didn't pay the $505 filing fee. So again, I took that as a threat in the regards of wind up being put in jail or whichever, you know. And I stated also in my letter that if that sound crazy and if that sound foolish, well then the courts in General Mills gave me that reason to believe that, due to the continuously conspiracy and deprivation of rights behind the color of law, and doing everything they can to protect this judge, Gary A. Fenner, and General Mills, and whoever else they're trying to cover up involving aiding in this type of injustice. And again, I would say to the American people, whoever to download this is ASAP, because like I said, I wouldn't be surprised if this type of information has come up, deleted, disappeared, or whatever it is. But nevertheless, it is in court docket, and it could be you at any time. So I still want to convey this here truth about what's happening, and let the American peoples know that, hey, if we got to go through our judicial court system and things around here, and corporation, as it is in this case, is General Mills, allowing certain or persuading certain judges and lawyers or whoever it is to cover up and pervert the law and abuse their authority and abuse the judicial court system and so forth to try to cover up each other's criminal act, well then, hey, you know. And like I said, that's not all judges, because there are some darn good judges, just like there's some darn good lawyers. But unfortunately, there's those who's not. As in this cause of action, there's, you know, the ones I'm mentioning, and there's even more than that. But nevertheless, I want to just let this truth be known.